Um, Hello and welcome to Module 5. Today we're talking about the regulation of national banks. As we have seen and will continue to see, all of the largest institutions are national banks. And when we see the advantages given to national banks in the law, it will make sense. So the OCC is the primary regulator of national banks. And that means that they will be the banking agency that charters or approves the charter, examines the charter, approves the charter, and regulates a national bank. They're also, of course, the primary federal regulator. Excuse me, for a state bank, it would be the state that charters the bank. And a state bank can either be a member of the Federal Reserve, if they're large, that's usually what they choose, or a non-member, in which case their primary federal regulator would be the FDIC. So you see these different combinations of regulation. Of course, all national banks are under the FDIC because all of these institutions have FDIC insurance, but the FDIC is really going to defer to the OCC as a practical matter for examination. As we read, there is also an agency that kind of works to coordinate, and that's the FFIEC, the Federal Financial Examination Council, so that all of them use some of the same examination manuals and use a lot of the same standards. And of course, there was also the Consumer Financial Protection Bureau that has the ability to examine the largest institutions and can react to complaints and concerns with the smaller institutions. So if one is kind of moving down the path of becoming a bank, the first piece is to decide, what type of a charter to seek. And as your reading talks about, there are advantages and disadvantages to being a national bank. It is a more onerous process. The state process tends to be more quick and informal and less expensive. But you do have greater powers, as we'll see, as well as more sophisticated regulations and regulators who can help you with the more challenging questions that you may have. But what's interesting, as we saw in the first case that we read, it is an individual examination process in that there must be at least 5 natural persons. And so it always goes back to who are the individuals in charge. And we will see this throughout banking regulation as, the board of directors are held accountable. There always has to be real people behind these organizations, and these people must have knowledge and experience. They must not have any kind of financial crimes. So, the first piece of chartering any kind of a bank, but including a national bank, is to find at least 5 natural persons who have the right kind of background. And the chartering process, of course, as you can imagine, is very long and complicated. The application is it's long, all kinds of financial information and business plan. And ultimately, though, it is up to the regulators to kind of give it the thumbs up or the thumbs down. And a lot of the application is public. The financial information of individuals would be private, but all of the detailed financial information of the chartering individuals does have to be submitted. It will be, hidden from the public view, but it will be viewed by the regulators. And ultimately, they have a great deal of discretion because it is an arbitrary, capricious, and abuse of discretion standard. And so for this reason, it's going to be kind of a dialogue with the regulator. You're not just going to submit this application and keep your fingers crossed. There will be pre-application dialogues. And even throughout the application process, there'll be the ability to amend and change, and it may be approved with conditions or subject to changes in the business plan or reporting. But, excuse me, regardless, it does start with an application, a formal written process. The regulator will review it and investigate it. As we see, there's antitrust reviews. And as I said, much of this public, and the fact that it has been filed as public and there is a public comment period, which the regulators will respond to in the final order approving or denying the application. As I said, most applications are ultimately approved, but they may request changes in the business plan or various things. But by statute, some of the things that the regulators are looking at is a reasonable chance of success. And this is really for the health of the banking system. One of the things that the regulations make clear is that whether or not the individuals make money is not the concern of the regulators, and except to the extent it's a byproduct of the bank being successful. As I mentioned, they're going to look at the moral character and capacity of the incorporators and the public convenience and need, which is somewhat like the reasonable chance of success. But it's a bit different, because this is where sometimes, as we saw in our case, is the market saturated? Do people need this? Does it fill a need? And so we did read a case. It was actually a state law case, but as you can see, the process is very, very similar. There's an application, review, and investigation. Here it's a public hearing. That's a bit old-fashioned now. There are occasionally public hearings. Usually everything's online, but they're looking at the success and the public convenience and need. And in this case, as we've seen in many of our cases, or at least we will see in many of our cases, the challenge comes from a competitor. They don't want a new bank in the area. And so they're not really challenging the individuals, their knowledge, their character, but they're challenging whether another bank is needed and whether it's going to succeed. And so what's kind of interesting, though, is that very quickly we see the court is basically saying, well, basically, the bank challenging this application is not a very good bank. They don't give very good customer service, and there is plenty of need and plenty of room for growth if you have a strong bank. But I think the case does illustrate that you are going to see challenges, and it may be your competitor that's doing the challenging. So the next part of our reading, though, also kind of gets to the chartering process, because the chartering process does involve a business plan, and that has to do with the bank powers. And the reading talks about there being some difference in powers between state and national banks, but they're not very great these days, because the FDIC sort of is a large cap on what, it regulates what states can allow banks to do, because all banks have to get FDIC insurance. And so although there is a different law that governs state and national banks, they actually are quite similar, and they all do limit banks' powers. And for a long time, banks were really just engaging in banking, and they were relying on this 12 U.S.C. 24(7). This is part of the original National Bank Act, where it says that banks shall have all such incidental powers as shall be necessary to carry on the business of banking. And then it lists some very key banking activities. And so for a long time, there wasn't a lot of debate about this, talks about receiving deposits, exchanging and buying money, lending money, all kinds of key kind of banking activities. But in 1972, we had a pretty significant case where, again, we see a competitor challenging a bank that's acting as a travel agent. And basically, the travel agent company says, you're a business, a banking institution. You can't carry on a travel business. But the OCC had put out a regulation saying that travel agencies were permitted as part of, the business of banking and necessary to the business of banking. And so the real debate is, what does it mean to be necessary to carry on the business of banking? And does that include a travel agency? And as we see in the case, and as common, they look back at the history, and apparently banks had been, somewhat involved in the travel business for quite some time. Although it really dates back to a time when there was at one time different currencies between states. And so, banking, you might go to the bank to make your travel arrangements and get your right currency. And so it becomes clear that though historically banks did operate as travel agents, it was in a very different capacity than the way travel agencies operated in 1972. And it was largely a convenience to its customers, not a true profit-making business. It was somewhat on the side and helping folks out. And so, interestingly, we see that the court has no problem setting aside the OCC regulation, which is something to keep in mind, that a regulation is not a statute. And so basically the court holds that although we don't read the word necessary in the way that I guess most of us think is necessary, instead indispensable, it does mean that it's convenient and useful in connection with those activities listed in 24/7. And it's really the footnote in the case, we'll see this more than once, that is what makes this case important, when it says that this is the standard it's going to use going forward. And so this is really the first case that starts to really make it clear the limitations on banks' powers. Now, there was another case that I want to talk about, although it wasn't really part of our reading. And this had to do with whether or not banks can broker annuities. And what's interesting here is we see an insurance company challenge, which we'll see again. There is a lot of back and forth between banks and insurance companies in the early days of banks' expansion. But here we see the court using something called Chevron deference, because the OCC again had said that banks could broker annuities and that there was nothing inappropriate about that. And by this point, we've had this Chevron case, which basically is saying that if the regulators fill a gap or an ambiguity and they have a reasonable interpretation, the court must give it controlling weight. And essentially that the court doesn't have to decide that it's the best solution or the best interpretation. It just has to be reasonable. And this issue is actually currently at the US Supreme Court, and we will be watching that. But at this time, using the Chevron deference, it was very easy to say that, selling annuities was part of the business of banking. Annuities are kind of quasi insurance, quasi-investment, and banks help somewhat with investment because a deposit account can be considered an investment or a way to save. But what was really important about this case, and the reason I want to highlight it, is that they held that the business of banking was not limited to those items enumerated in 24/7, those core banking items, that those were just examples. And so this set the stage for the idea that the business of banking, while limited, is an evolving concept. And it's very important because it's what has allowed banks to get into, electronic banking and things that were not thought of when 24/7 was enacted. And so we sort of get to this place where the business of banking is evolving, but yet limited. And some of the things that the regulators think about is whether or not it's the functional equivalent or a logical outgrowth of something banks have always done. And this is how it was determined that finance leases were permitted because it's like a loan. So leasing wasn't thought of at the time of the National Bank Act, but it is permitted for national banks. Also, does it benefit the customer or strengthen the bank? And so these are things that make banking and financial transactions easier for customers and the bank. And is it the similar types of risk? So is it an area of expertise? So this is how we have things that are dealing with money and numbers, moving money, investing. Of course, not investment banking, but safekeeping of money. And so this is what the regulators look at. And so I did ask you to look at a couple of questions at the end of the reading, and one of them has to do with the OCC regulations and, you know, the public convenience of need. And I think I kind of covered that, you know, essentially the banking regulators are looking at whether or not the bank will be successful, because for the system to be successful, each individual bank needs to be successful. And to be successful, there needs to be a need for the bank. Is it going to attract customers without hurting essentially the other banks in the area or the other banks that it competes with? The next question asks, you know, why are there limited powers? And I think, you know, it's something I'd like you to think about, but, you know, traditionally, one of the concerns did really relate to FDIC insurance and, you know, whether banks would use that sort of government safety net for other risky business opportunities. That has been one of the rationales. But the next note that I did ask you to read gets into something we'll talk about a bit more, is that we do have something called industrial loan companies, which, as we'll talk about in the context of bank holding companies, do not have the same limitations in their holding company structure. So it is a way that we've seen some exploration, not in the bank itself, but in the holding company structure, of kind of mixing the business of banking with the more commercial activities, which we think of as sort of the manufacturing of goods, the selling of goods. And so, you know, there are those who think that the limitations are not necessary, that they're antiquated. I don't see any big changes in that, but it is something interesting to think about. And the ILCs are a very kind of interesting piece of that, which some argue to show that it's, you know, not nearly as necessary to limit the business of banking as we have historically required it to be. So let me know if you have any questions. Thank you.